It is so square. Borders between a denial, a violation or infringement of a right, a threat to a right, or fundamental freedoms. We address you on the basis that the section under which this charge sheet has been premised, that is section 94, subsection 1, was enacted in 1930, with the commencement date being the 1st of August 1930. It follows therefore, Your Honor, that with the enactment of the new constitution, the old EPP who has brought us here this morning ought to have been alive to the provision of section 7 to the 6th schedule to the constitution. Section 7 to the 6th schedule, Your Honor, to the constitution provides that all laws that were in effect before the effective date shall be read with the necessary modification, adaptation, alterations, so as to bring it into conformity with the provision of the Constitution. And while I am not inviting you to look at the constitutionality of that section, I am inviting you to look at whether or not the application of that section falls within the provision of section 8 of the Magistrates Court Act. I want to make it clear so that my learned friends on the other side may understand that I'm not invoking your jurisdiction to determine the constitutionality. I'm invoking your jurisdiction to determine the applicability of that provision. Therefore, in that sense, Your Honor, section 94, subsection 1 must be brought within the armpits of section 7 to the 6th schedule. And the reason why the drafters of the Constitution made a proviso to save the existing laws before the effective date was to make sure that, Your Honor, that granted the circumstances that Parliament is not able to address all laws supposed to bring it to conformity, that the application of such a section may not result into violation of a provision under the Constitution. That is the reason why we have the clause saving the existing laws before the effective dates, and hence the enactment of section 7. Having said that, Your Honor, section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating a policy. In this case, Your Honor, you are implementing the law. And therefore you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is the value of human rights. That human rights binds you. And that is why section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice and the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equal application of the law granted the circumstances and the submission that he has made, because I consider them to be legal arguments. Number two, Your Honor, the application of Article 10 invites you to look at the question of discrimination and Article 27. Because Article 27 falls within Article 10 where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jane Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one limb of our argument. The other limb of our argument is that the same does not disclose an offense. Those are two grounds. That if she was to make or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94 subsection 1